I'd like to welcome our next guest. During the formation of Democracy Action, I came across Stephen Franks and his team in Wellington, who offered some legal support and helped to understand the Unitary Plan and the process taking place. I'm very grateful to Stephen, who fully understands the implications of this new legislation. Stephen is a frequent speaker and writer on legal subjects with a particular focus on company and securities law, criminal justice and constitutional issues. So please welcome Stephen Franks.
Thank you very much, Lee, and I do want to thank Sir Bob as well, although I had helped influence the order of batting that I didn't have to follow a really good speaker. And certainly at a time when most people would like to have a snooze after lunch, it's supposed to be the worst possible time to follow a good speaker. And I think you brought us back, as we need to be, to the common sense reaction that most New Zealanders have, as you say, Maori and Pākehā, which is remote from the consciousness of those who are creating this new web of law, very well-meaning and completely oblivious, and I think deliberately oblivious to the costs. I haven't done the proper thing, of course, and introduced myself. I should possibly have gone through and said what my mountain was and my river was and given a proper introduction. But I should explain why a constitutional lawyer would be here instead of a resource management lawyer. I really will hand over to those in the audience who will know more about resource management if we get through to questions and planning law becomes material. But I'm here because what is happening, what you're doing by turning up to a meeting like this, by 1,100 of you putting in submissions against the mana whenua provisions, you're really not protecting just your own properties. You're starting a pushback that's really important for New Zealand as a whole. It's not just the devaluation of Auckland property, it's not just frustration for Auckland. Most of the rest of the country quite enjoys watching Auckland get itself into pickles. It's a silly and short-sighted attitude, but there is always amusement in the rest of the country when we see something like $30 million being spent on the plan that was billed as being short, simple, and the same across the entire region. But I'm here because, as a constitutional lawyer, as a parliamentarian, and as a lawyer generally, I'm terribly conscious that when you have an unwritten constitution, it looks very fragile, but is usually considered really strong. And the strength of it is a widely shared, almost universal view about what is unthinkable. They're unwritten because we and the United Kingdom, now almost alone in the whole world, felt we didn't need to write down what we don't do or what power is not allowed to do. And so we have big areas of our law where in other countries there will be some express rules and prohibitions that say the executive cannot do X, Y and Z. And they have courts who then adjudicate on whether or not those boundaries have been breached. But we don't have anything that says all must be treated equally before the law, because we assumed that that was a given. Our unwritten constitution had conventions that we didn't cross. Among them was equality before the law. And I got into quite a lot of trouble a few years ago. I say political trouble with my party or with people in my party, because I was the spokesman on Maori affairs and the justice spokesman, and I had to lead my party's support for Maori against Michael Cullen's Seabed and Foreshore Bill. And we did that, we voted against it because we believed that in a society that treated all equally, Maori had a right to go before the court to have their property right, their property claims adjudicated, and it should not be taken away by Parliament simply because there might be an outcome that upset a lot of us. And I say I got in trouble because there were many members of the party who were really apprehensive about where the court itself was leading and where the court might suddenly decide to do a bit of pioneering and create rights for Māori that others didn't have. But we thought the principle of equality before the law and the principle of legality was so strong that we had to support the Māori Party and those who thought it was a bad law. I believe in property rights, and property rights don't work if they're vulnerable to officials who can apply undefined or vague terms at a whim, or where people can be exhausted by the process costs of defending their expectations. And I'm here because, as a lawyer, I'm concerned about the, Bob called it cowardice, that is spreading out from this industry, from the treaty and the Maori wonderfulness industry, and is actually seriously affecting my own profession. I heard Lee refer to some of the comments about people who have expertise in the area and have encouraged him. I called 7 different lawyers in Auckland to run the hints session that we'll have from Pam. One lawyer, the first one I contacted, who I knew, said, look, why don't you go to the QCs? The RMA QCs are made Queen's Counsel because they accept that they've got a public duty. The label means counsel for the Queen. They take that on as the leaders in the profession. I tried the QCs. They said this was a very good idea, that the process that had been adopted to bring the mana whenua provisions in was extraordinary, and probably there were bits that wouldn't see the light of day because they were underhand. They said that the objectors were on the right track, but neither could find the time to be here. Now, they may have very good reason for that. I didn't probe, I'm not going to be rude, I wasn't accusing them. But they did suggest others. I tried big firms. I chaired Chapman Tripp for some years, so of course I tried Chapman Tripp and I tried other big firms. And they were quite blunt about it, and I understand it. One of them said, our major company and developer clients have to think of the long run. They can't afford to be vulnerable to an adverse counsel view of them. Our clients need to be able to get on with the officers. Good on you. If you need any advice, if you're doing it, if there's something you can't understand, let me know and we'll give you a hand. But our clients expect us to be able to ensure that they get the best result, and we can't do this. This kind of fear used to be something that I would not have expected in the legal profession. The profession justifies its privileges on the grounds that it stands without fear or favour before the state, and it protects people from the power of the coercive powers of the state. And another one said to me, good luck to you if you find any Auckland planner or lawyer who will give evidence in the area that you want to tread. It's too sensitive. This one said, I suggest you go to someone in Wellington or even Christchurch, somewhere out of Auckland who doesn't have to practice in Auckland, and get the expertise from them because it won't affect them. And so I'm here because I think this is serious to a country with an unwritten constitution. This kind of fear of being politically incorrect, this fear of being some sort of retaliation, it may be that it's entirely unjustified. I think the council officers here today are probably saying that's nonsense. We wouldn't take it out of someone. But people just don't know. And I can say a former client, yes, it is a former client, whose position I respect, a utility, inquired about helping with Democracy Action's submissions, and eventually the decision came back that they simply couldn't risk damaging the investment they'd made in relationships in Auckland, I think with iwi, they didn't say, but I think with iwi, not the council, and that therefore they could not be seen here, but once again they thought this was a very, very necessary process and wished us all the best. I'm also here because this resonates for me with something that happened about 13 years ago. I was in the Justice and Electoral Select Committee, and on my committee was Nanaia Mahuta, who is standing for the leadership of the Labour Party at the moment, and Mita Ruranui, who was a Labour Member of Parliament and a very nice man. And the government had just set up the Royal Commission on Genetic Modification. And they'd announced that they were going to go to ask Māori all over the country at a series of hui what they thought of genetic modification. And just as a sort of conversational thing between items, I said to Nanaia, I'm really baffled by that. I don't even know what genetic modification is all about. I'm sure my father, who's my kaumātua, would be very puzzled by anything technical on genetic modification. Why would there be a particularly Māori view on something so modern we hardly know what it is? And Nanaia just laughed and said, yeah, well, you know, of course they've got to go out and show that they're being respectful to our people, but yeah, I don't know anyone who would know enough to say anything useful on genetic modification. And Mita Ruranui agreed. Well, I was in the committee about 2 years later when the Royal Commission reported, and the report, I think it's about chapter 6, has a very eloquently written description of the hui where there were riro flitting in the rafters and the intensity of feeling and emotion as they were told by Māori of what fear and risk genetic modification offered and how they felt so apprehensive about it. And I was just had it with me to swat in downtime, and I pushed it across the table to Nanaia and said, what do you make about this? You told me that Māori wouldn't know any more about genetic modification than Pākehā. And she said, what do you think's going to happen when a whole lot of serious looking people with glasses turn up and they ask our people seriously what they think of genetic modification? They're going to have to say something. And I think what we witnessed was the invention of some serious spiritual concern about something that would never have occurred to anyone. And I venture to suggest that we've seen or are seeing the same thing happening at the moment. It appears that council has gone to many of the iwi in this area and paid them $10,000 to consult about what they wanted in the plan. And I wouldn't be surprised if I were in the position of an iwi leader. If someone paid me $10,000, I'd feel obliged to have some concerns to justify them paying me. And not surprised that someone's temporary rubbish dump or the site of a picnic of shellfish is now possibly a site of significance. The council knows and has acknowledged that they don't know whether many of these sites have any cultural significance. The iwi don't know. They say that the purple circles of 200 metres diameter with 50 metres on the outside of those circles, which work out at about 7 hectares each, those circles are precautionary in case there's something of significance. These things pick up a momentum that carries on. I'm looking around here, probably some of you remember when the Minister of Justice in 1991-92, who became a hero for his treaty settlement approach, Sir Douglas Graham, told New Zealanders they didn't need to worry. The treaty was a treaty between the Crown and iwi and hapu, and it wouldn't affect a square foot of private land. And I don't think any of us have ever had a chance to vote on whether there should be a change from that position. If there was to be a change from that position, it would certainly be one of those matters that in most countries you would need a constitutional referendum. But here we are today, where there are 3,600 circles on the land maps of Auckland, where all the titles within there are devalued by what might be the view of 1.8% of the population, or the leaders of 1.8% of the population, about cultural and spiritual impact. That is a really substantial constitutional change. Lastly, as to why I'm here, I think it's hopeful that this one might have gone too far. This might be the issue, the straw that breaks the camel's back, where people will feel that they can speak out the way Sir Robert does. People like hearing him because mostly they never hear what he says, even though they think nearly everyone they know shares the view. They never hear it from anyone in a leadership position. But you remember when the news of this first broke, Shane Jones for the Labour Party denounced it. A few days later, the Herald editorialised against it. Dick Quacks and Mike Lee and Sandra Coney and other councillors from both sides of the spectrum have made it clear they believe they were misled about it. And I'm optimistic, and I'm here because Lee Short has stood up and said it's not enough for us just to complain to each other. I'm going to do something. Let's make the most effective program we can. Let's get back and deliver power back to the people who think like the majority, and come across to show what a really determined opposition, 1,100 submissions, over half of them prepared to turn up to hearings to show what we can do. It's an optimism for a start. You'll find, if those who haven't already started in the hearing process, that there will be quite a lot of frustration and possibly humiliation in it. The processes may end up where you get 5 or 10 minutes, it'll look as if no one's listening. They possibly aren't. If they've heard hundreds before that are making the same points, it'll be very hard for them to look interested. And yet, and it may appear that it's all pre-decided and that they're just going through the motions, and they may be. The council, for example, was obliged under Section 32 of the Resource Management Act to do an assessment of the costs and benefits and whether there are alternative ways of achieving the objectives of these mana whenua provisions. They then spent money on NZIER, New Zealand's preeminent economic analysts, to audit their Section 32 analysis. The Section 32 analysis looked at the mana whenua provisions, and it's in polite language, but essentially it says we can't see any evidence that they tried to work out the money cost of any of this. So there's a piece of law that says you must do a cost-benefit analysis, and they go through pages and pages of analysis, and there's nothing there that tries to work out what this costs or what the benefits might be in money terms. Even more interestingly, the audit says it doesn't appear that the council gave itself any time from the receipt of this analysis to go back and have a look at the proposals with a view to making sure that the bits that perhaps didn't stand up to cost-benefit analysis were modified. In other words, it was just a ritual. There was never an intention to review whether it met any cost-benefit test. And then the audit says, and we haven't seen any evidence that this cost-benefit analysis, which had some critical stuff in it, in other words, it said that didn't seem to have looked at alternatives, and it didn't look as if they had really estimated the costs, even the non-financial costs. The audit then says, and we can't see any evidence that the councillors who had to make the decision ever saw this cost-benefit analysis. So we have council officers who appear to treat the Section 32 analysis, Parliament's balancing of the worthy goals, who appear to treat the Section 32 analysis as if it was just an empty formality. There's another reason as a constitutional lawyer. What the council has done with these mana whenua provisions is double up on and duplicate and supersede, but go much further than, a pretty carefully worked out balancing process that culminate in an act called the Heritage New Zealand Puhere Taonga Act, which was passed 2 months ago. It's the replacement of the Historic Places Trust legislation. And it has a whole process for a Māori committee and a general committee to go through sites nominated for heritage protection. And it interacts very well with the Resource Management Act. And when these sites have been identified and categorised, they then get automatic protection, and they also have to be respected by council in their planning processes. The RMA itself has a fairly well-balanced set of protections. Among them is protection against what you've ended up with potentially 16 or 19 iwi competing to say that they've got cultural offence or spiritual views about the midden in your midst. One of the protections in the RMA Act is that it says tangata whenua is defined as the iwi or hapu, the singular, with mana whenua, which is mana whenua is also defined and means the exercise of customary authority in an area. So the Resource Management Act contemplated that there might be reasons why, you could understand it, why there would be consultation with a hapu or iwi about the sites that they had actual authority over. What your council has done for you is say there could be up to 16. And talking to one of the people who, in fact, one of the rarities when we're investigating this, one of the people who's quite happy to be identified here, tells me that the relationship in his area, Omaha, Graham Painter might speak about this later, they have a relationship with the iwi in their area, and their iwi have said quite bluntly, no one else is coming in to tell us in this area how we treat the significant sites and the heritage sites in our area, and that's as it should be. Because the notion of shared management or co-governance or kaitiakitanga, which is being spread throughout New Zealand, isn't a notion that was familiar to Māori. You controlled it, or someone, and if you kept control and kept your fires burning on the land, or you didn't. It's wrong. I mentioned 1.8%. That's a simple calculation taken from the website of the Independent Māori Statutory Board. That the Māori in Auckland are, I think from recollection, around 17%. No, it might be more than that from their website. But those who are actually tangata whenua, or who are mana whenua in the definition the council has used, I simply multiply the percentage of Māori in Auckland by the percentage that they represent of Māori, and we get 1.78%. As a constitutional lawyer, to provide inherited, indefinite or permanent privilege over how people use their land is reinstating a kind of inherited feudal system where you must culturally doff your cap to, or pay seigniorage to be allowed to use and enjoy your own land. The treaty is part of our constitutional inheritance now. The courts have said it is, and the courts have said that principles exist, although they change all the time. The treaty, Article 2, actually says very clearly that classical English property rights became part of the inheritance of New Zealanders. What this system is doing is encouraging Maori, who possibly have suffered the most of all abuses of their property rights, to become the new abusers of property rights. Your land, under what Article 2 said, should be for your exclusive use, enjoyment, and power to alienate or not. It's your power to do as you will on your property. And that's what Article 2 promised to Maori. Quite a radical concept in a society that had assumed collective ownership and power exercised through a chief. But that was what Maori bargained for, and when it was offered in the English version, it was offered to Maori. In the Maori version, translated back, quite interesting words: to all the chiefs and tribes and ordinary people of New Zealand, exclusive use, possession and enjoyment of your land. That's what rangatiratanga offered. In Article 2, which is where rangatiratanga is mentioned, I think it's almost beyond argument that the missionaries made that word up, and that they were trying to represent the English concept of your home is your castle. You are the chief of the land that you own. And in that article, it offers it to all the ordinary people of New Zealand. Now, this is before democracy, remember, in New Zealand. It's inconceivable that the chiefs would have assumed that their chieftainship was being offered to all the people of New Zealand. We had a description of a property rights which this system, which the mana whenua provisions, is trashing. As was said by Lee, and as others would say, and others possibly will say, you could choose to go to court. Judicial review, I'm satisfied there are elements of the way that this has been introduced that you could get the courts to say this is improper. But the core thing, the thing that really needs to be re-established, is a respect for the secular nature of our law, the fact that we signed up to the convention in 1971, we passed the Race Relations Act, and we signed up to a convention that we would eliminate all forms of racial discrimination in New Zealand. We also have just assumed that we're in a democracy where the executive power will be controlled by people we elect. And what we have in the mana whenua provisions is a proposal that has the effect of law from the moment it was announced. That's a decree. From the moment it was announced, rules that are being enforced that traduce those principles that people shed blood to establish. So I'm here because I've been engaged by Lee, but I'm also here as a labour of love, if you like. This is an opportunity with the people who've put their time and their names and will put further time into this to start reasserting some of the things which most of the country is absolutely committed to and is scarcely aware is under serious threat. But finally, I'm here for friends, including Maori friends, because this isn't working for anyone. We've had quite a close look at the provisions from the perspective of iwi. If the Independent Maori Statutory Board did a ruthlessly practical cost-benefit analysis of what they get out of the right to extract cultural impact statement assessments, it's a poison chalice. First, the fees that might be extracted are trivial. in comparison to the assets that iwi now have. Maybe $1 billion, who knows? There'll be someone or people here who probably know more, but it's well north of $1 billion in Auckland. These rights to assert cultural offence or to explain cultural offence are likely to be used by some hothead or some opportunist in some iwi in ways that will embarrass the rest of them. There'll be tanawhas invented. There'll be spiritual offence taken, which most iwi will say, that's nonsense. We've never thought that, or if we have, we've given up. Just as most of us come from a background where we've given up things that we used to be offended at. And they will all bear the odium that gets attached to these bad stories. But the council's rules don't provide any way of disciplining there. They say expressly that iwi are the judge of what the cultural value is. So although the assessment is stuck into a regime that is the same as where you have a hydrologist or an engineer or some other expert, so that the assessment goes in as if the people giving it are experts, there's no provision for testing expertise. There's no way Maori organisations, as tribal organisations, aren't actually very good at getting rid of their duds. Even if most of them want to get rid of their duds, they find it really hard because they're not democracies. Or if they are democracies, they're shaded democracies. There's no statutory protection if these things are done negligently. One of the things we've looked at is grabbing one or two of them and then testing in court and taking the iwi to court because they're effectively exercising a delegated statutory power and just making an example or two because of some casual statement or some casual claim of a spiritual or cultural value. But most of all, it's like beads and blankets. It's a power to throw your weight around. It's a power to demand respect because people have to. But it's a power that's really hard to turn into substantial benefit for the iwi or for the other side. So it's a situation where people see the money that gets involved in it as pure dead loss. It's not a substitute for the real property rights that were promised in the treaty. And most of all, it will lead, as indeed it could lead us, and it shouldn't, it'll lead us into pretending respect in the face of the officials and of the iwi representatives, and then of course regaining our mana because it's demeaning to pretend respect for something you think is nonsense by stories of derision behind their backs. It doesn't do anything for race relations. I hope that we see in sites all over Auckland and Wellington and elsewhere, I like seeing plaques. Catherine Mansfield was born here. I like to see the carved poles that tell me there was a battle here or something grand happened here. I love the idea of history and I want to see it commemorated, but I don't want to have done nothing at a time when a regime is being created that trashes democracy and elevates a permanent tiny minority to a sort of aristocratic caste state in our law. Thank you.
Thank you, Stephen. Thank you very much. Well, on your chairs, I've left some information there, a brochure and also a form to fill out. Lone voices are really heard, and to be more effective, we've got to coordinate our efforts. And my wife, Susan, and I, we've funded this initiative so far, but we need some help. Quite a considerable outlay at the moment, over $50,000 has gone into this. And we do need your active support and your financial support. And we need to build a bit of a fighting fund to go forward from here because we need to bring about change. I'd like to introduce our next speaker, which is Pam McMillan. Pam's a senior solicitor at Franks Ogilvie. She's specialising in public law, including areas of local government, education, infrastructure, regulation, as well as other issues. Pam's done a lot of work on the plan, and she's given you some handy hints here about how to present to the hearings panel. You only get 10 minutes, and she's going to go through those with you. So please welcome Pam.
Thank you. I'm Pam McMillan. I work with Stephen Franks. I'm a solicitor, specialising in public law, local government, commercial law. As Lee and Stephen said, tried to get a RMA QC here, but they didn't want to come, or they had other things on. I'm not a QC. I have had experience in appearing at oral hearings, in select committee and at council hearings, but I haven't had experience in this particular process. So this will be a practical session, and we'll be asking contributions from the floor. There may be people here who have more experience than me, or who have been to the pre-hearing meetings. So when we start going through the hints, if you have a comment, a question, or advice to anyone else here, and we'll be asking you to stand up and give your contribution. So to start off with, because you've been sitting for a while, I thought we'd do a sort of a practical exercise. If you wouldn't mind, if you could stand up if you have written a written submission on the unitary plan. So anyone here who's written a submission on the unitary plan, if you could stand up.
On this topic?
On any topic. Thank you. So that's the bulk of you. If you could remain standing, sorry, this is an exercise. If you could remain standing if you intend to make an oral submission. So if you intend to go to the hearings panel. So not many people have actually sat down. Now, if you could remain standing, and you can move around a bit, if so far you've found the process to be quite complicated, daunting even, confusing. That's still the bulk of you standing up. Thank you. You can sit down now. One more exercise to get you standing up again. If you could stand up if you have written your written submission on behalf of yourself or on behalf of a group and you haven't had a lawyer or an expert involved. That's great. Thank you. Sit down now. So the purpose of this session is to help those people who are appearing for themselves or for their community group on how to make a good oral submission when you do go to the hearing. This particular, first of all, I'll give a little bit of background to the hearing. This particular hearing is unlike any other hearing. The hearings panel is not under the RMA, which is what it usually is. It's under special Auckland legislation. The members were appointed by the Minister for the Environment. So usually when you go to a hearing in council, you go to a panel which is appointed by the council. This particular hearing panel is independent, supposedly from the council. They have a team of 8 members. Chairperson's Judge David Kirkpatrick, who is an Environment Court judge. There's 15 mediators as well, who are lawyers who help with mediation before pre-hearing. There's also a bevy of council staff who will be helping with the administration of the hearings panel. The reason for the special hearing process is that this is the first unitary plan in the country. So it is, as Lee said, it's a huge plan. It is, it's 10 lever-arch volumes of text, 3 volumes of maps. Some of you may have gone onto the council website and tried to find a map or an overlay map. It's quite complicated. More than 9,400 primary submissions, 3,800 further submissions. So there's a lot of submissions for the hearings panel to go through. We understand about half of those have elected to make an oral submission, so elected to speak before the hearings panel. The timing, the plan was notified on 30th September 2013, and then the hearings panel has about 3 years until the council finally makes a decision. So the hearings panel needs to give recommendations to the council by 22 July 2016, and they can get a 1-year extension. So that could be July 2017. Then the council needs to make their decision on the recommendations from the panel. And as you probably all know, they can decide either to follow those recommendations or not to follow them. It's up to the council. This is the council's plan. Now, with the actual plan, you would have made a written submission, and some of them would have been divided into topics. So if you've made a submission which covers more than one topic, say for example subdivisions and mana whenua, you'll be invited to 2 hearings. So you would have got a letter saying you're invited to this pre-hearing and to another pre-hearing. As we're here today about the mana whenua provisions, I've just put up on the PowerPoint the dates for those 2 topics. So there's 2 topics. There's the regional policy statement, which is 005, and then there's the mana whenua, which is 009. And it is a complicated process. It's more complicated than a usual hearing. So some of you would have gone to the pre-hearings. They're different dates, and I've heard that they can be quite complicated. You're given a few minutes, and that's mainly about procedural issues. Then you have to RSVP for the hearings, so you do want to go. Eventually you will get a time slot for your time. And then there's evidence due, notice of cross-examination, which will be mainly for the experts or lawyers. I understand some community groups are getting planners involved to do expert evidence, which is a really good idea. At that stage though, at evidence, anyone who's made a submission can give evidence, and that includes writing an email, attaching a photo, any sort of evidence you want, get before the hearings panel before you appear. So if you can, take note of those dates, and even an email to the panel. Yes.
Sorry to interrupt, but I don't understand the difference between evidence and my submission.
It's to back up your submission. So you made your written submission, and evidence could be things which have happened since you made it. For example, you may be taking photos, or you may have got a letter from the council. It could be various things. It's optional. You don't need to give any evidence at all. Even when you go to the hearing on the day, you can give handouts. Yeah. We have been advised though by an RMA lawyer that it is best to get as much before the panel beforehand as possible, because they will be apparently doing pre-reading. In other words, they will have read your submission and anything else you've sent before you arrive. And then there's the actual hearings. If you have RSVP, they will be giving you a time slot. I'll sleep again. Oh, there you go. Okay, on the back page of the pamphlet that we left on your chairs, there's a list of handy hints. We sort of got these from talking to different RMA lawyers from our own experience in appearing in select committee and council hearings. But I am aware that there's many of you here who may have other experience, so please just put your hand up if you've got anything to offer. So the first hint is to arrive early. You will be given a time slot. If you're unsure of that time, give them a ring the day before. If you're unsure of where to go, give them a ring the day before. Make sure you know where you're going. Arrive at least an hour early. I understand from November you can go onto the panel website and book a time. So if they've given you a time that's not suitable, you can contact them, change it. Don't be daunted because it is a hearing process with an independent hearing panel. They are able to make up process as they go. They're very aware, I should assume, that a lot of the submitters do not have lawyers involved. You know, they're submitting on behalf of themselves. So there will be flexibility. When you do, it's your turn to stand up. Start by introducing yourself. If you're appearing for a group, introduce who you are appearing for. Things they will be really interested in is how are you affected. You talk about where you're from, whether you're within 50 metres of a site or place of value or significance, things like that. We understand that the panel is going to keep to the time limits very strictly. Unless you've asked for more time, you'll be given 10 minutes. Then they'll move on to the next person. So usually when you go to a hearing, it's good to have something prepared, so make sure you've got enough prepared for the 10 minutes, but leave time for questions. Often that's the most valuable contribution from the panel's point of view, is if they want to ask you a question. So have your speech prepared, practice it at home beforehand. It's always good to know, that you're going to speak for 5 minutes or 7 minutes or whatever. The speech that you're going to do, or your time slot, make sure you don't try and rush through all your points. I've made that mistake myself, practicing for court, trying to say as much as you can, all your really good arguments, all your good points. You won't have time for that. Choose your most important 3 points, 3 or 4 points, and do a summary. Something that I often find when we go to select committees, they really like stories, they really like examples of something different, because there will be hundreds of submissions. So if you could tell a story or give an example of something that affects you personally, that's more likely to be remembered than a whole lot of academic points. When you are speaking, try and have eye contact rather than looking down. You will have to look down now and again, but eye contact, speak slowly, clearly and confidently. It's your time to have your say, so you can take the time that you like within the 10 minutes that is. When answering questions, it's really important to try and listen to what they ask, and then speak slowly and confidently when you reply. If you don't understand the question, ask what they mean. They will elaborate. If you are in a group, it's good to have one spokesperson, but have the other 2 or 3 sitting next to you. They might help you with the answers, or they might want to give examples when there's questions. As I said, you can give handouts. Something may have happened since you made your written submission, for example, or you've heard of other groups giving handouts or having photos. You can take those along to the meeting, but make sure you have enough copies for all of the panel members. And there could be up to 8. There'll be a minimum of 3. I think for the 005, we've been told that there will be the full panel. So there will be probably 8 people sitting up the front. There'll be all the council officers or council officials on the side. So probably take about 10 copies if you are going to do that. It is a public meeting, all the hearings. So anything you say will be, there could be media there, could be other people in the audience. If a reporter does ask you to speak to you later, it's up to you whether you want to speak. If you don't, decline politely. So that's really all my hints, but if anyone has any questions or any advice to other people who've been to pre-hearings, if you want to put your hand up. Yes.
Lynn Hume from Carl Island. A couple of things. First of all, I noticed that the date to RSVP to the hearing was yesterday, and unfortunately I missed that.
Well,
And a whole pile of others, so I put it. What I'd like to be able to do is get in touch with people so that I can join onto their one if necessary. Went to a pre-hearing yesterday for 033 and 034, which happened to be about moorings. And what they've done now is they've put two things in between the pre-hearing and the hearing. So now they are going to have conference of experts, and if you know anything about it, you're allowed to put yourself an expert, and you can have your own time plus expert witness. So I put in for 2 for that, which gives 2 lots of 10 minutes, which gives us 20 minutes to speak. And then it's going to go to a non-binding mediation where you will be able to speak again, and then you'll be able to go to the hearing. And I'm wondering whether the same thing is likely to happen on 009.
it could happen. I understand.
Just repeat, summarise it. Yes, summarise it. Going back.
So, sorry. So the question is, will there be mediation expert conferences for 009, like there has been for other topics? And the lady said that if you have an expert witness, that means you get 2 10-minute slots. You may also be invited to a mediation or an expert conference. So from what I understand, the mediation is to resolve disputes or confusions before you get to the hearing stage. So that would mainly be things like zoning, boundaries, mistakes that may be made on maps, things like that. I don't think it'll be for 009, but I'm not sure.
Or missing the dates, she asked.
Missing, yeah, the dates. Well, there's no dates for those here because that will be up.
October the 17th.
Oh yeah, that's right. If you've missed the RSVP date, it's not too late to RSVP. Yeah, I've read the procedural minutes. You can RSVP later. So long as it's not too late. But it's a good option also if you can't go to the oral hearing, you can join another group. Yeah. With the expert conferencing, I think that is to resolve confusions about interpretation of the plan. We've heard that there are quite a few definitions which are difficult to understand. So instead of going to court, there may be expert conferencing with experts to resolve disputes over that. Yes, down the back.
Pam, how would you handle just a philosophical opposition to the whole issue of mana whenua, where you didn't have a specific issue that was affecting you? It's just a philosophical opposition to the whole issue and the way it's been done. How would you handle that?
In the hearing, you would have made your written submission already. You introduce yourself. You would say, I would like to talk about the philosophical issues to do with mana whenua. Explain what you want to talk about. You don't need to have come from a particular area of Auckland, which is next, 50 metres away from a site of place of significance. But these issues may be as important to you as someone with a property. I'll just talk exactly about what you're talking about now. Stephen might have something else to say.
I'll take a note of that. There may be a number like that, and it may be, especially if you've got a speaking slot, it may be a good opportunity to go into some of the more technical reasons why this is a frolic by Auckland all on its own. I mentioned that the mana whenua, using it as a noun instead of as a verb, as the power, is quite novel. We could actually use your slot, even if you put it in as a philosophical objection. It might be possible to give you a submission that would use your slot to point to the provisions in the Resource Management Act that are inconsistent with that. and to point to the provisions of the Heritage New Zealand Puhere Taonga Act and say this is actually this is ultra vires. This is outside the powers that should be read into the constraint. It should be read in as constraints on council. So I would think that the panel, the hearings panel, will be conscious of the importance of your question, and we might be able to help them to turn it into a technical question rather than a general philosophical one.
Oh, yes.
Thank you.
Yes, yeah.
Yeah, I've made numerous submissions, quite a lot, and I find the whole thing very daunting. I'm invited regularly to pre-hearing meetings, and I ring up to find out what do I do, and I was told, oh, well, look, unless you've got some objection that something is wrong with what your original submission is, you don't need to come along. So I haven't been going along, but then I hear, oh no, you should have been going along. So I haven't had anything to say I've been invited to any hearings yet to, you know, whether I reserve my right or not my right. But with the Maori one, I haven't got a zone around my property, but I'm in an outstanding landscape area, which immediately has concern to Maori. And there must be a humongous amount of people in the Waitakeris that affects that haven't come under this, you know, zoning or ring around their properties. It's just because you've got this designation, this layer on it, you are affected. And that's really taken away all your rights as a landowner.
Yeah, for the first question was, what if you didn't go to a pre-hearing and then you missed out going to the pre-hearing? What does that mean for the hearing? We were invited, we're acting for a couple of clients, we were invited to the pre-hearings, but we emailed the administrator from the panel and said we're quite happy with the pathway chosen, which was straight to the hearing, so therefore we don't need to go to the pre-hearing. So if your pathway, and you should have got an email saying what your pathway is, which is probably to the hearing, you don't need to have gone to the pre-hearing. So you don't need to have gone to the pre-hearing in order to go to the hearing, in other words. If you haven't RSVP'd, like we said before, it's not too late to do it. The second question was about landscape. If you're not living within 50 metres of a site or place of significance or value, but you may be living in a ecological landscape area, still affected by resource consents and CIAs. Yeah. So therefore, it is worthwhile making a submission on that. I'd say a lot of people in Auckland will be affected one way or the other. We have got the actual rule here. Should we try and find that?
I think there was a slightly more general question, is it worth going to a hearing if you haven't got much more to say than what you had in your written submission?
No.
I know that was what I thought your original...
More that I did get invited to the pre-hearing meetings, but I've had nothing since those pre-hearing meetings to say I can go to a hearing. Yet my neighbour, one of my neighbours, he's received notifications of a hearing in December, and my name is down as a speaker, like as a submitter. But I haven't had anything from the council.
I think if you didn't go to the pre-hearing and you didn't say in writing why you weren't or that you weren't going, they'll assume that you're not interested in going to the hearing. So therefore, you've got to actually contact them and say, no, it was a mistake, or I actually do want to go to the hearing. So there will be flexibility, but anyone for the 009, there still is time to do your RSVP. So definitely put in writing that you want to go to the hearing if that's what your intention is.
Thank you.
Stephen,
Yes.
could you answer your own question? Because it's a very good question. If you've got nothing more to say, is there any point in saying it?
The question... I'd really be glad if someone who's experienced in RMA processes would add a comment. I'll just say, having been on the Securities Commission, having been a parliamentarian on Select Committee, and therefore having sat on the other side of the table on hundreds of submissions, I think it is nearly always worth presenting if you really mean something to you, because the ones that don't present are usually just summarised by staff, and they're often just categorised, and so they'll simply say plus 45 submissions on this point, whereas if someone turns up, there's a chance that there's a connection and it sticks in your memory and it's more persuasive. So in my view, subject to what an RMA lawyer or a planner might say, it's almost always worth turning up, but it's not worth simply repeating what you've written. If you turn up, you really need to think of an illustration or to be bringing to it something that is more than just an abstract, a repetition of your claim. So I think it's worth it, but bring something extra. If a simple example in this area, I'd seen a submission that referred to a shell midden, which was one of these things that had been quoted, and it said it had been disturbed. When we actually spoke to the person, he said you can only see it because a drain's cut through it, and beside the drain there's a footpath, and what was the shell midden, most of it will have been in the drain. If there's any of it left, it's now under a road. Now, that's a much more vivid picture for the hearings panel to get of something that is scarcely going to become an icon, or no one's going to go and sit at that particular historical site feeling waves of history pass over them. So if you can just make your point in a way that you would want it to if you were on the other side, you want to know, is this important and why is it important? Or are they just parroting something that someone told them to say?
I think that particular submission also mentioned how many years their ancestors had lived in that area, lived there for over 100 years, and their familiarity with the area, and they didn't even realise that shell midden was there. Yes?
I'm from Carlisle Island. I've got 3 properties up there, and they're all affected by this historical heritage circle things. I wrote to council putting an objection in against it and asked them why this designation was being put on them. I could get no answer. So therefore, if I go along to speak to anything, what am I going to talk about? I've got no evidence to speak about at all.
I can tell you why they
down the back, you mightn't have heard that. It's got 3 properties on Carwell Island, and they've got circles on them, or they're subject to some of the circles. And he wrote to council asking why they had been designated and got no answer. Pam might like to explain. A lot of these circles, according to the New Zealand Archaeological Association, a lot of these circles are on spots, GPS sites or spots on the map where there may once have been something of interest that had been placed for archaeologists to have a look one day. And many of them have actually been looked at. And in fact, it may even be most of them. They've had someone go over them and decide that there really isn't a significance to them. But the process by which all those circles got on the map, as we understand it, and the council officers may correct us, the process was simply going through either at the request of the Independent Maori Statutory Board or at someone's initiative, and sticking circles on them all, whether or not they'd been dealt with. So you could easily find that there's nothing there. And that's one of the reasons why the audit, the Section 32 audit, was so interesting. People have been put to all this trouble and expense, and it will continue, without anyone doing the elementary thing of making sure that it was actually something of substance. I was a company securities lawyer. If the same lack of care that has gone into this had gone into a prospectus, if people were able to make statements as loosely that have the consequences that this has in company or commercial law, there'd be people looking for defence counsel on criminal proceedings.
First of all, I'll just explain this slide that I've just put up.
I don't think they can read it.
You might not be able to read it at the back, but it sort of explains how the 3,600 sites were found or were put on in the plan. They're from the cultural heritage inventory from the council. Okay, and they were chosen because there was some Maori origin and there was a GPS location or GIS location. This is from the Archaeologists Association submission, and they've actually put the CHI description on the right-hand column, which describes whether or not the site actually exists or whether it's been destroyed, what it was, things like that. And there's a few examples. I'll read them out because you may not see them at the back. Just things like location and survival not known, midden, reported par, recorded from historical information, pits found not to be an archaeological site when tested. Yes.
Could I understand Dr. Blakely's here? Could you comment on the sort of the truth of that statement? How were these sites identified? Whether in fact many of them are known to already not exist?
Yes.
We would be pleased to answer that question. We have a presentation we'd like to give which would help answer a lot of these questions. So as soon as we can have the opportunity, we'd appreciate the chance to do that.
Are there any more, has there anyone got any strong corrections, hints, suggestions? Because we should probably move straight on now for the council officers. There's one here.
Well, perhaps people should be drawn to the attention of the AUP website and the fact sheets on it. They're a hell of a hard to follow and very legal, but I understand from those that any evidence you submit's got to be in a very prescribed form.
Yeah. You can go onto the panel's website now under 005 and see the type of evidence they're accepting, and it's quite a range. The actual guidelines of, as you say, are very technical. They're for lawyers. There are quite a lot of lawyers making statements of evidence who are expert witnesses, but they're also accepting any sort of evidence. Just go on there, have a look. There's emails, there's letters, there's photos. They will accept them. I think they are quite aware that a lot of submissions are being made from property owners or community groups. So there will be a variety of evidence accepted. I think they'll have a different standard for lawyers.
Another question, this might not be the right time, but I've made submissions in the past to councils and it was fine. You addressed a bunch of councillors and some of them were awake, and you got the impression that they were going to come to they were in the position they could come to some compromise between the original plan and what you'd submitted. And they did. But I'm not quite clear here. I get the impression here that it's a very legalistic process and they're bound between what the plan says and what the precise word of what the submitters say. Will they be able to come to some middle ground?
Yeah, the question was about in the under council hearings, there is some compromise between what the plan says or the proposed plan says and what the submitter says, and councillors are involved. This is a different process. The members of the panel weren't appointed by the council, they are independent. It is a lot more legalistic, a lot more formal than previous hearings on the district plan. This plan is a combination of, the regional policy statement, regional plan, district plans. So you're right, it is more legalistic, but the same people are doing the same submissions.
Are they looking for a middle ground, or are they bound for a precise legal way?
We don't know. It will be up to the hearings panel to make their recommendations in about 2 years' time, which will be about July 2016. They will make recommendations to the council, who then have 20 working days to make a decision on whether they accept or don't accept those recommendations. So it is a different process, you're right. It's under the Local Government Auckland Transitional Provisions Act, so it's a totally different process. Yes,
Question for Stephen. Stephen, are we not dancing with fairies with all this? I mean, should we not be going straight to a judicial review? We've already had the situation where you've had good advice and that this thing is illegal anyway. And here we are messing around with all this paraphernalia, people coming along that the commissioners might make it or might not. They don't know what decisions they're going to be doing. And then it goes on, the council can take a decision, or the commissioner will not take a decision. Why don't we go straight to a judicial review, and that irons it out and puts it straight in the parliament?
The question, it sounds as if they heard your question. Why not go straight and challenge it in court? I would say that quite a number of these issues, the court would say there's a process to be gone through, and that may correct it. And courts are reluctant to intrude where there's a process that could result in the right outcome. And so you're quite right. I mean, there are some bits that, yes, you probably could knock out. And I think that there would be some very useful stuff, because it would probably result in clear identification of the illegality. So yes, it could, but there are bits of it that would remain. It's expensive, and while you go to judicial review, things tend to go on ice, and so you'll potentially extend the period of uncertainty.
Well, in answer to that, you've given us that these things have come in as a decree, and that is illegal. Now, can we not get an injunction against the decree to put that out for the thing while you go for a judicial review? I mean, we're paying thousands of dollars out for this thing that is illegal anyway, and it's come in by decree, as you say, and we're paying all this anyway. Why not just stop it in its tracks and let the thing take its course with judicial review?
Well, I'll give you an example. I say that it's come in by decree. Unfortunately, Parliament allowed decree effectiveness for some kinds of plan change. So that the relevant section of the Act says that from the moment of notification, a plan change is enforceable. One of those is where it protects areas of heritage value. The reason we think that you could probably knock it out is that for quite a lot of the sites that actually exist, they're already protected under the existing heritage legislation and the RMA. There's plenty of room to say they're protected, so this stuff doesn't actually protect anything. So you'd go to the court and say, it can't apply automatically. Give us a declaration that it doesn't apply now because it's purporting to protect something that's already protected. It's redundant. We could probably win that. At least a good example is in Omaha, where we know that that's been closely examined. But you'd win that, but you've still got all the rest going on. So it would be a bit of a bloody nose for the council, and it would give us some clarification on what is and isn't automatically applying. But in my view, this won't really be corrected until there's a political perception at central government level that exposing communities all over New Zealand to this kind of abuse of power has to end, and they've got to change the law. So I think that the long run, the full-timers wear you down. The officials who believe in this and they think it's really good for the community and they are sincere in that belief, they will keep this stuff running until the law says you can't do that to people. So I'm just concerned that a win in court is too partial.
Thank you.
Yes, question here.
We've got material here. The resale of Auckland in 1840 after pre-treaty sales, given back. The chiefs who blessed land to the Crown and other buyers, they sold a wahi tapu for £2. Now, there's a huge amount more than that. A lot of the statements and claims are gimmicks which have no legal meaning.
Can I just say, I'm sure there's a lot of material of that kind, and it really, you may want to put that to the hearings panel, but in terms of where we're going and hints, it doesn't really fit. I'd rather, we've talked a lot, and I'm sure the council officers are burning to answer and to correct what may be misconceptions. I'd like to ask them to present now, and then we'll come back at the end of that and have a session where anything that you've been meaning to say or ask, we have a general wrap up and a general session and a where to from here. So, Dr. Blakely, if you and your people would like to start now. Thank you, Pam.